going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Happy Wednesday. Good to see you all. Yeah, it's great to see you all. I don't really have much to say to start with this. I do want to shout out a few people. Thank you guys so much for reaching out to me to make sure I was okay after last night. Yeah, no, I appreciate that. I'm good. I'm good. I promise. I'm good. Just, bad days happen. They do happen. Before we do start, I do want to shout out Julie. Thank you so much for the PayPal after the stream ended last night. I do appreciate that. That was awesome of you and very generous. All right. You guys want to get ready for tonight? So tonight, I've got a continuance or a follow-up on an attorney who got into a lot of trouble. It was about a month ago, where he used ChatGPT to file his court documents for him. And turns out they weren't real. At least what ChatGPT cited as far as, court references, they didn't exist, got caught out on it. Yeah, it was a big thing. That was about a month ago. We got the follow-up. We're in Judge Tammi Hayward's courtroom, and yeah, I don't really want to say anything else. We're just going to do it. You guys ready? All right, I'm ready. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right, this is the 1 p.m. calendar. This is Ada Melina Costin Cruz versus Diaris Nellums, Peachtree Truck Leasing versus ProMed Imaging and Unified Medical. But essentially, the case took a turn because at the last meeting, the attorney for Costin Cruz, the plaintiff, Mr. Tristan Gillespie, presented a document to the court that had, was created by an AI application, an artificial intelligence application, and there were cases cited to and presented to the court as legal authority that did not exist. And so the court made a record, assisted by the Mr. Kennedy, who's the attorney for the defendant, who had gone through and basically noted all of the instances where there were documents, where there were cases cited in the document, but they did not, were not actually cases under Georgia law to which the court could lean for legal authority. All right, so at that point,
Kimberly, thank you so much for the 18 months. I appreciate it. 1.5 years. That is awesome, Kimberly. Thank you.
Informed Mr. Gillespie that I would be sending this information to the state bar, which I did. And I have not heard back from them other than that they have received the information and it is in process with the general counsel for the state bar. But I did tell Mr. Kennedy and Mr. Gillespie that we would reconvene to determine what sanctions, if any, the court would impose. All right, and so I have Ms. Middleton. Yes, ma'am.
Good afternoon, Your Honor. I represent Plaintiff Cruz. We filed an entry of appearance on December 31st. I left counsel a voicemail this morning, and we do have plans to connect after this hearing.
All right, so Mr. Kennedy, I did ask you for your suggestions for the any sanctions that the court might issue in this case, but I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond.
Sherzad, my favorite, not an Egyptian. I just found out she's Syrian. She lives in Egypt, but she's not an Egyptian. I still want to say my favorite Egyptian though. It's so much fun to say, but you're not. So my favorite Syrian. Welcome.
And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct.
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor, certainly much more educated about the pitfalls and dangers and so forth. And clearly, it's not sufficient to rely on large language models to I guess, verify or validate case citations, and so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. So I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
Okay.
Yeah, no, it doesn't work like that. I'm not a lawyer, and I know it doesn't work like that. Look at Judge Tammi's face. She's like, no, you wasted the court's time. You wasted your client's time. You massively disrespected the court for your filings that you posted that you got from, I still call it ChatGPT. He called whatever he said, a large open source. No, stop it. No, use ChatGPT, and you didn't even read what you got back. No, this is on you, my friend. This is on you. As an attorney, no. Come on.
Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter, the primary matter that involved the plaintiffs and defendants in this case. I had to spend court time addressing the fact that you sent in a brief that was essentially fiction. And so based on that, what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time, you're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent.
Alex, you just missed the defendant speaking. He's not really the defendant. He's the attorney that used AI. You just missed his I'm going to call it like I see it. The absolute bullshit response that he just gave the judge. And she's laying it into him right now. That's it. We just started. You're good.
Ms. Caston Cruz, because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, I mean, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think bare minimum under OCGA 91514, I would ask for my client's reimbursement of all of our fees.
Playing from Tristan's iPhone.
All right, don't know what that
Go
was.
ahead, sir.
Yep. All of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed. And it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's written documents submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said nothing. We called it out and we asked him what was going on, and the response was, you want me to provide additional briefing? Or just, oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolved all the prior behavior and, sins of counsel, so to speak. And you can just now wash it all away and move on because we've got an
Yeah, Maria. That is something that he stated when in the initial appearance. Like I said, it was about a month ago, where he said he practiced. And I want to say maybe New Jersey. It was a New England state, New Jersey. I don't know, but yeah, it was multiple states. Maybe it was Maryland. Maryland. Yeah, it doesn't matter. But yeah, multiple states.
Another lawyer involved. I mean, my clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further, but I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say. And so that's exhibit D to that motion. It's my affidavit of fees.
All right.
If I may add, Your Honor, we don't disagree with the procedural history of this case, but we would like to object to counsel's dismissal.
Wouldn't be my dismissal, it would be the court's dismissal, but.
Well, your suggestion of the dismissal.
Okay.
Dismissal. Okay. All right. Well, you say you're objecting. You got to give me some basis for your objection.
Yes, Your Honor. So the plaintiff here has terminated previous counsel. It's my understanding previous counsel has also been terminated from the firm as well. My basis on the objection would be that plaintiff had, no idea this was going on. And as
There we go. He got fired. Rightfully so. Using ChatGPT to file motions, and you're not even going to read over them. I want to know how many times he got away with it. This isn't the first time. It can't be the first time. But this is a civil case. It's not criminal. The actual client's not here. Neither one of the clients are here. But how many times did he get away with it before he got caught?
such, shouldn't be prejudiced because of this. My goal would be to get this case back on track. It's my understanding there was a consent motion to discovery filed with discovery expiring, I believe, the first week in March. So we would want to be as diligent as possible and still maintaining that deadline and getting the case back on track.
I want to be mindful that the parties in this case are not the primary drivers when it comes to filing motions and attending to court processes. And so if I'm going to sanction in any case someone who's acting on behalf of the parties, if Ms. Caston Cruz is unaware that her attorney is filing fiction, it would be unnecessarily punitive to her. I get that the case has not moved in a manner that is expected. But civil cases tend to have issues with timing anyway. Civil cases can, there's no real expectation of how long a civil case is going to take. We hope for things to be done in a timely manner. We have a structure for how discovery should be conducted. We have a structure.
I think if he gets disbarred, yes. If he's just sanctioned for this and he just has to pay a fine, probably not. But if he absolutely gets disbarred for this, yeah, I'm sure they can relook over other filings. But yeah, I don't know. I'm not an attorney.
For how cases should proceed, but mere timeliness is not something that we can really. That's really a factor that we can guess about or know about from the outset. What I do have is a desire.
Yeah, I don't know what link you're asking for. I don't know if that's a joke or not, Julie. I don't know. This case happened 3 or 4 hours ago, so I don't have a link. Like I said, I don't know if that's a joke or not. I can send you a link, and you and your lawyer friends can come up and discuss this case with me right now. But yeah, I can't send you the Zoom link for this court.
To make Mr. Kennedy's clients whole, in as much as he's had to respond to these motions, he's had to spend court time, he's had to spend office time, he's had to address all of these filings, and then the volume of the filings, when really to tell me to file a huge filing just to tell me that you relied on ChatGPT to tell you that ChatGPT was right. We had a training for judges about the use of AI, and essentially the main thing that was beaten into our heads was you are responsible for everything that is produced, whether you use an artificial intelligence application or not. There are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings, but you can't rely upon, especially something that is open source material at this point, like ChatGPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. It is software for people.
I forgot to unmute. No, that's a good point. If what you get from ChatGPT is correct, you'll be fine. You'll be fine. The problem is when it's not correct. And I will tell you, I've used ChatGPT a lot over the last couple months, and I'm a big gamer. A lot of you know this, but I'll ask ChatGPT a question about a game I'm playing, and it'll be flat out wrong, and I know it's wrong, and I'm just like, hey, that's not correct. And it's like, oh yeah, you know what? You're right. After re-looking, like, okay, if I notice that on a game, how often are you wrong? And you just come out and just say, yeah, no, you're right, I'm wrong. It took you 1 second to figure out that yeah, I wouldn't use it for anything serious, guys. Don't do it. It's wrong a lot.
One of my friends uses it as, she says, like it's like her wife. She'll say, hey, make a grocery list. Hey, write this letter for me. Hey, set up a schedule for my children. And so it is assistive in that way, but you are responsible still, because I'm so old school that this is the phrase that keeps coming to my head: garbage in, garbage out, which we were all told when at the outset of, and I'm old enough to go back to when.
Yeah, that's a programming term. That's a computer term. Garbage in, garbage out. You put garbage in, you get garbage out. I think a lot of people know that. That's not an old school term, Judge Tammi. You're not that old. Stop doing that to yourself. Uncle Dan. Sorry. The Dandoff the White. So this is the attorney that used ChatGPT or some AI software to file court motions about a month, 2 months ago. And the other attorney, what's his name? Kennedy. He came to court and just said, "Hey, everything that he filed, all the citations are incorrect. There are no such citations. The ones that are actually real, he's not even using them the correct way. I think he's using AI." Now, the attorney, Mr. Gillespie, said, "I don't know what's going on. I don't know what's going on." And yeah, so they continued it till today. Judge Tammi was pissed. She was furious, and she filed sanctions against the guy and turned him into the Georgia State Bar. So this is the follow-up on this case. That's where we're at. Dandoff the Gray. There's your summary.
We switched from typewriters to personal computers, and to software, to the software for personal computers that allowed us to type and produce documents. And so at this point, I'm not inclined to dismiss the case, because I really feel like Ms. Caston-Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case. However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court, and giving case law.
You can find it I covered it. Just if you go to my channel, just click on my icon, go to the homepage, just search either ChatGPT or AI. It'll come up. You'll see it. It'll be Judge Tammi. It was about a month ago. It's there. You got it.
And statutes upon which the court can rely. And so with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston-Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents, and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. And I saw it, but I can't find it now. What is the amount that you're seeking, Mr. Kennedy?
So as of August, when I filed this, it was $25,498.08. That's fees and costs.
All right. So, Mr. Gillespie, there will be a judgment against you personally a sanction against you personally for the amount of $25,000 for $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am, and then we'll get it back to the insurance company who's paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand.
Yeah. You just wasted a year's time on the court. Yeah, $25,000 over a course of a year for your fake filings. Sorry, man. I don't feel bad for you. That does seem like a lot. That's a lot of money. He messed up though. I don't feel bad. I really don't.
That that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
Mr. Kennedy?
His alleged transgressions. No one's saying that it's possible that we're just alleging this. No, you admitted it. You admitted it. You did. You claimed earlier on the video that what you did. So we're not alleging anything. Isn't he a lawyer? He should know these things. Don't talk. You might just walk. In this case, yeah, $25,000.
I didn't go through and itemize. Like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court and in this case, so I'm not going to nitpick at this point. I feel like from the outset of a case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file, if you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that is an excessive amount. So $25,498.08, that's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
Judge, is there a timeline you want to put on that?
120 days.
Dang. Yeah, you just lost your job and you have 4 months to pay $25,000. Good job. You did this to yourself. I don't feel bad for you. You did this to yourself.
And would you like a proposed order or will you have one?
Please submit one.
Okay. Your Honor, if I may, I know you've indicated you're not inclined to, dismiss the case on a sanctions ground. Are you planning on taking up the summary judgment motion today too?
Dan, you're going to find out real quick. Miss Middleton is the new attorney on the case. So we're still actually here for a real case. Just Mr. Gillespie, that issue had to be taken up first. They took care of that. Miss Middleton is the attorney on the firm that Mr. Gillespie used to work for and covering the case now for I don't know. I think it's a damage claim, an injury case. I don't know. It's civil. I don't know. Dan, it's right up your alley, actually.
Miss Middleton, you're just coming into the case. Can we get back on track with the merits of the case?
I believe so, Your Honor. In all honesty, I have not had a chance to really take a look at that motion for summary judgment. I did see some mentions of reopening default in the docket. If counsel's willing to get this back on track with discovery, I mean, we would have no reason to oppose that, and I'm happy to get on a call with counsel once this hearing wraps as well.
Here's
Okay.
my only issue, Judge. So I filed this motion for summary judgment because they didn't respond to requests for admission, right? So under OSCGA 1136, those are just deemed admitted. And the case law is very clear that to overcome those deemed admissions, they've got to provide credible, admissible evidence that would refute them. And there is none right now. I mean, they filed a reply brief that had an affidavit from their client that is inaccurate, and we can go through it if you want. I can show you exactly why. She's got, first of all, a different date of a motor vehicle collision, saying I was involved in a motor vehicle collision on January 4th, 2024 on I-20 in Douglas County, Georgia. And can I share my screen on here?
Your Honor, if I could be excused, I know a lot of this going forward doesn't pertain to me.
Yes, Mr. Gillespie, you may be excused. We'll get you in order.
Oh man, I would make him sit. This is why I can't be a judge. I'd be like, no, you'll be excused when I excuse you. You're going to sit through this until this hearing's over. All right, Mr. Kennedy's about to share his screen, and he's going to bring up a police report which has a lot of personal information on it. So I'm sorry I have to do this, but I have to. I try not to dox as much as possible. I got to.
Can you see my screen, Your Honor?
Yes, sir.
Okay, this is the police report from our case. As you can see, I can try to.
I have December 14th, 2023.
Right, in Gwinnett County, totally different day than in her affidavit, sworn affidavit that has been submitted to this court, which again is just kind of consistent with how things have gone, says that this is the day that she got in a motor vehicle accident and was injured. I mean, I don't know what to do at this point. That's all. The only evidence they have, apparently evidence in quotes, is this affidavit from plaintiff that says she was injured in a motor vehicle collision on a completely different day that she supposedly received medical treatment for. But then again, we've got these requests to admit that they're deemed admitted that basically say, my medical treatment wasn't caused by this accident and wasn't necessary, and those sorts of things that just completely defeat her case. So at this point, I'm not sure there's a lot to even argue on their side as to how they overcome a summary judgment motion. So that's why I was asking I know you're not inclined to dismiss it on just a pure sanctions ground under 915.14 or because of the contumacious conduct to the court, but I think I'm also entitled to you granting summary judgment in my favor.
All right, Ms. Middleton.
I mean, the fact that there's a police report showing that the wreck happened, I mean, obviously there's some meat there. I mean, we would obviously object and request for an additional 30 days to respond to the motion for summary judgment, if you would be inclined, Your Honor.
Well, kind of not, because at the point where I guess you came into the case.
Yeah, I mean, kind of not. Your sworn affidavit doesn't even have the date right. Then we have this attorney who's using ChatGPT to file his motions that don't make sense. He got fired. Yeah. I feel so bad for the actual client here. The law firm should pay the client whatever she's entitled to get, that she thinks she's entitled to get at this point. No. So much bad.
We had been dealing with the sanction issue, and that has been more than 30 days. So from that point, Mr. Gillespie and the firm and whoever he's dealing with had noticed that there was a pending motion that the court did not hear, and that there was time at that point to address that pending motion or to come up to speed on what that was. And at this point, the court's not inclined to continue to delay this issue. To Mr. Kennedy's point, if the discovery is deemed admitted and we're dealing with the basis of, okay, these facts are a part of the record, then you have to come with the strongest evidence to show that the deemed admitted facts have that there is something to counter those facts that have been admitted by failure to respond to discovery. So just the fact that there are 2 police reports or 2 incidents of an accident, one in January of 2024 and one in December of 2023, the existence of those divergent things is one thing, but none of that is enough to overcome what has been admitted.
I'll also just point out that she also in the affidavit says that she was struck from the rear by a vehicle. And I can pull it back up, but the police report from our case, she was backed into. So it's like a completely different mechanism of the way the accident happened too.
And given the procedural history of this case, Your Honor, I do think we have good cause to possibly withdraw or amend those omissions. I would want to move to do that.
Well, that's already been done.
This is the issue that I'm having, though. Y'all have, I don't know how you got into the case, Ms. Middleton, and so I don't want to beat up on you too bad. But the issue is that y'all have had plenty of time, because since we had the first sanctions case, I know that was probably sometime in early October, or I feel like it was October.
August.
It was August, because I've gone to judicial training since then. I've come back. We've had the holidays. So since August, we've had a substantial amount of time for you to file whatever you wanted to file. Because had I decided to accept your filings, fine. They're already on the record. Let's deal with them. But I didn't restrict anybody from filing anything. The only thing I asked for at the point that we left in August was for information about the filings that involved Mr. Gillespie and the sanctions. I don't know when you came into the case, but there was plenty of time entering the case to file whatever was necessary to protect the rights of Ms. Caston Cruz. And so if you didn't make use of that time, there's not a lot I can do in this case.
Well, and Judge, they did file a response to my motion for summary judgment, and they did file a motion to amend or withdraw their deemed admissions. It's not like nothing's been briefed and been filed. This stuff was all briefed and is in front of you and was briefed.
Be careful. Be careful. I've got a lot of attorney friends that are in this chat and that watch on replay. Yeah, I don't agree with you. You're entitled to your opinion, but I'm just going to say I don't agree with you.
Back in September and August and October.
The issue is, though, that I don't have a lot of information that says we need to overturn the admissions and reopen that part of the case. And also, I'm kind of leery of what was filed because it was filed by Mr. Gillespie. At this point, the court has no confidence in the validity, viability, or legal basis of anything that Mr. Gillespie files with this court.
So am I taking that as you're disregarding basically his response briefs and the pleadings, the briefs he's filed? And at this point,
unless I'm hearing an argument from Ms. Middleton.
Again, Your Honor.
I've answered this a few times. I don't really know. I know that the last time I saw her, she was in Judge Simpson's courtroom. She was bouncing around a few places. I've called her assistant a few times to try to get an interview with her. She's still there. That's all I got. We just don't see her on YouTube. So I don't think that she's really, done anything so bad where she's not on, no longer a prosecutor. I know the last time we did see her and Judge Simpson kind of got into it, but yeah, that happens every once in a while. So that's all I got for that. I don't really have a good answer. I don't. But yeah, I think I do believe she's still a prosecutor. She's just not on YouTube anymore. That's all.
We do not disagree with the procedural history of this case. We started the case on November 26th. We have been having difficulties getting the file. So, I do apologize if my knowledge of the case isn't exactly in alignment with the procedural history of the case. So I do want to be honest about that. But, again, we would want to move to withdraw and amend the admissions, based on the previous procedural history of this matter.
So when you came into the case, you came in relying on what Mr. Gillespie filed, and you didn't file your own or amend?
We did rely on the Felicetti firm, which was the firm that Mr. Gillespie worked for. I knew that he relied on ChatGPT for the filings, and I knew that that was an issue. But in terms of the admissions, I really wasn't aware of that.
The issue is, and I know you know this, Judge, so this isn't going to educate you, but the problem is for them to be able to withdraw and amend their admissions, they have to show that the admitted under InterSouth Properties versus Contractor Exchange, which is 199 Georgia App 726, the admitted request either can be refuted by admissible evidence having a modicum of credibility or is incredible on its face. And at this point, there is no evidence in front of you at all to refute the admissions. I mean, that's the problem.
No affidavits, no certified copies, no
medical
exhibits
record
filed with yeah.
There's just nothing. So there's one 5-paragraph affidavit that we've already shown is not even reliable. So I'm sympathetic with Miss Milton. She's only been in the case for a couple of months, but
you're not the first person to ask for it. I have it on my channel. I'll search it up and I'll post it in the chat so you guys can watch the first hearing. But you're not the first person to ask, so I'll just do the work. I'll find it.
at the same time, you don't always inherit the best cases, I guess. It's just how it goes sometimes.
Well, and this is what I say. The case at that point, if I'm coming into a case that is problematic, I would amend the filings. I would ask for leave of court if necessary, but I would definitely amend the filings that were already done to preserve the issue, but to amend them to perfect them such that by the time that we actually argued the case, then the amended filings would take care of whatever deficits were done before. There's nothing that prevents you from amending a pleading. There's nothing that prevents you from, if your response was done by the previous attorney, coming in and amending and updating that response or providing additional evidence that would support and give the court a basis for the decision to overturn the fact that the admissions had been deemed admitted.
Or bringing evidence or witnesses to this hearing. There's a lot of ways to do it. But Your Honor, I think you could issue an order in such a way that it wouldn't extinguish any claim that the plaintiff may have. Not against my clients, but if that's of concern.
Is this a first filing? This is not a refile?
To my knowledge, it's not a refile.
My knowledge as well, Your Honor.
Although, if I'm not mistaken, maybe I'm getting my cases mixed up. I think the complaint says it's a refile, but I was never aware of a first filing. I'm gonna look right now.
All right. Okay, so the court is going to make a decision in this case. and I will issue an order. Mr. Kennedy, if you will get me an order on the sanctions, I'll go ahead and sign that.
Okay.
All right, Ms. Middleton, the cases are what we get. You know, I was in civil practice too, so I understand that sometimes if you take over from another attorney, it kind of is what it is. But let me have some time to consider all of the. You know, I'm not a superior court judge, so I can't balance the equities, as it were. But I do have to consider, you know, fairness and balance those things that would affect each of the parties in this case. So, all right. Thank you, Mr. Kennedy. Thank you, Ms. Middleton. And we will get an order out to you.
Thank you, Your Honor. The only, before we go, if we could, and this may be something that I can work out with Ms. Middleton, I don't know, but we do have the motion to open the default as to liability and set aside the liability judgment as to Peachtree Truck Leasing Company.
Peachtree Truck Leasing, right.
Right, which we were going to take up in August, and then we never got to it.
Yeah. So what we had talked about was the default was in, and then we were talking about whether damages hearing would prejudice the remaining parties in the case because of the information that had to be presented during the damages hearing. And so that's sort of where we left it before all of the issues with the briefs.
Right, and so you already ruled that we couldn't have a damages hearing because there was still one defendant that wasn't in default. This is a slightly different issue because I'm asking you to open the default and set aside the judgment as to liability as to Peachtree Truck Leasing altogether because they're an improper party in the first place. And I told Mr. Gillespie, but I'll tell Ms. Middleton now. I know who the proper party is. I've put it on all the briefs. And all I'm asking is that we just swap out the parties so we get the right entity in here. I'm not trying to hide the ball or extinguish any claims or anything. We're just trying to get the proper parties in. And Mr. Gillespie was, I guess, holding on to his default judgment that he'd gotten as to this Peachtree Truck Leasing, which again is not a proper party. And we didn't want to agree to lose that. I don't think the plaintiff is prejudiced at all by getting the correct defendant in here and litigating on the merits, since we already have Mr. Nellums has not been in default at any point. But that's the issue there. And again, maybe Ms. Middleton.
Okay, let me ask this. Do you also represent the proper entity?
I do, yes. So there won't be any issue with that.
All right. That's easy to do. Hold on. Rob and Dan, this is for you. If anyone else besides Rob and Dan clicks on this, I'm not going to let you up. So Rob and Dan, that's all you. Let's go. And also, it's Muse's birthday. Happy birthday, Muse. Happy birthday. I love that. Happy birthday. Thank you so much for hanging out with us tonight. I do appreciate that. That's awesome. All right. First special guest. This is the Dandoff. Welcome. Welcome.
I need to get a staff, and
You do. You do. Thou shalt not pass.
Thou shalt not pass. Yeah. No, this is a fascinating one to me. Very interesting because I do get frustrated when I see a lot of judges are just really reluctant to dismiss cases, and I've seen it on both the. I am dealing with one now. I can't say too much about it, but dealing with one now where the defendant has done tons of things that are like outrageous. He keeps losing his attorneys. It's an individual. It's out of a corporate thing, but our allegations are the guy took a bunch of money from the firm, from the company. So,
all right.
So it's not, we're not beating up on nobody, but done things that should have earned him the sanction of dismissal, and hasn't done. And I'm pretty sure he's used ChatGPT for stuff, although he doesn't know enough to use case law in it. He just writes factual stuff and lots of scurrilous things that we're pretty sure he's using ChatGPT for. But always it's been a frustration of mine that there are these rules. You go and you file a motion for summary judgment, and the other side doesn't come in and doesn't follow the rules, and the judge said, well, it doesn't matter. Part of the rules matter, so I'm a big one for saying, hey, we've got these rule books for a reason, and let's abide by the rules. And you've got to get, when you have a motion for summary judgment, there's a time to file your response to that. And if you don't file your response to that, or if you file a response that's inadequate, well, that's on you. If there's a problem for the plaintiff, as there seems to be in this case, although I have some concerns here about this plaintiff, but if there's a problem for the plaintiff, sue the firm, sue his firm, sue Tristan Gillespie's firm.
Yeah.
Just there's you have to prove the case within the case, as they say. You have to prove both that he was committed malpractice, which would be easy to do. I mean, I think that's a given. But then you have to prove that had he not committed malpractice, he would have won. And that's the hard part of it. And that's why malpractice claims are typically pretty difficult to win, because you have to win the case and the case within the case.
All right. So it doesn't matter if the attorney just completely butchered that. You still have to have a winning case to win a malpractice case.
Effectively, yes. Although the other truth is, I don't know what the claim was here. Rob made a good point that an insurance defense firm spent $25,000 on defense costs. Back when I was with a big firm, we'd spend that very quickly. You file an answer. I was doing all defense of typically product liability claims. By the time you file an answer, you typically have to be $5,000 into it. By the time you got to the summary judgment stage, you're probably $100,000 into it. Right now, when people ask me a question, well, what's going to take to prosecute this case? The plaintiff's side, the answer now is at least $200,000. So anyway, that's, not motor vehicle cases like this is an MVA case, motor vehicle accident case. Those are typically a little more cut and dried, but $25,000 is a chunk of change. But I have some concerns here, because I ran into, I took one pro bono case. I'm used to taking pro bono cases, and I took a pro bono case that on behalf of a defendant who was sued, and it turned out I was quite sure that it was a motor vehicle accident. I was quite sure that the guy had bought up the claim somehow, and thank you, Kimberly. He had bought up the claim somehow, and the actual client, the actual plaintiff, the allegedly injured party, we didn't think she was injured at all, but the allegedly injured party was not involved at all. So some of this, when I hear this affidavit doesn't match the facts at all, I'm thinking, yeah, it's a cut and paste affidavit. And they just got, they're using somebody else's affidavit, and they didn't update it all. They were just lazy. They just took somebody else's affidavit, copied it, slapped somebody else's name on there. I can't be sure, but that would be my concern about this case. I'm not suggesting, not saying that I know that they did that, but I would look into that certainly if I had to deal with it, further than this. I'd want to find out if maybe they just slapped somebody else's name on a pre-existing affidavit. It just raises issues, raises issues for me.
No, I get it. I mean, we saw what the attorney was. He just got kicked off the case and charged $25,000. So, do we think that it's outside the realm of possibility that he cut and pasted an affidavit? No.
No, I mean, given what the guy did otherwise, I wouldn't be at all surprised if he cut and pasted the affidavit, or he may have met initially with the client, and then but then the client goes away, and the guy just, I've got to have an affidavit to respond to this motion for summary judgment, and just puts one together. Yeah, Bill Nivar said, yeah, especially since the date was wrong, and the accident was wrong. Moon Rain makes a point there. Washington State and Oregon. I didn't know about Oregon. I practice out of Washington State. In Washington State, yeah, you can practice law. You do have to pass the bar, although they've changed things, and there's some limited practice for some people now, and I'm not clear what those rules are. But you can take the bar if you've done Rob, remind me what it is. If you have to work with a licensed attorney for some number of hours.
Yeah, apprenticeship.
Yeah, apprenticeship, and it's like 4 years. It works out to like 4 years working with them, a long time. I knew one lawyer who did that, and he was quite good. He was quite a good co-defendant's lawyer in a case we had, a table saw case, and he had done that. He was representing one of the co-defendants, and he was a good lawyer. I liked him a great deal. So it's a cool way to get into it.
Well, yeah. So, Dan, Rob, you guys, Dan asked to come up, and he invited Rob.
Oh, yeah, Rob and I.
So what's going on? What's going on?
Rob and I were arguing. I'm doing my usual browbeating of this nice gentleman, but Rob was saying, well, I don't know, dismiss without prejudice. Let him come back, and I'm like, oh man. They go in, they file the motion for summary judgment, and they screw it up. They say all the time, you're the agent of the client, right? And the client is bound by the statements, just as in any other agency relationship. The client is bound by the statements that you make and the conduct you take in performing under the terms of the agency relationship. And so whoever this client is, yeah, they said these things, they did these things, the attorneys did those things in those years, and you're bound by them. And Rob does a lot of criminal law where you wouldn't do that. You wouldn't do criminal. But
well, yeah, and that's a bit of a difference in philosophy. There is I do 90% criminal law and 10% civil stuff. So for me, when the state makes a bunch of mistakes, they get to just keep going. Nobody stops them. So, but for me, it's and this is all going to be governed heavily by whatever the rules of the state are, is when the client makes no mistake and makes a good faith effort and is relying on the expertise of their attorney, and their attorney is just blatantly incompetent. I find it hard to stomach that they're just denied any potential relief on any claims that they have. But Dan brings up a good point that hey, if that's the case, then you kind of have to do the 2-stage trial. First, prove misconduct, and then prove that you would have won the case but for the misconduct, which is a pretty high burden. But then the law firm's on the hook there.
Yeah, and my problem is that, okay, you're going to be nice to the plaintiff in this case, but there's a defendant in this case, and you're being nice to the plaintiff and the defendant. Even if you pay them, they're still the defendant. Oh man, there's one thing that I tell new clients when they come in is, remember that there's the cost that you're going to be writing checks to us, right? You're also going to be losing a ton of time. It is, your own cost and your lost time and what's going on in your head is a very significant cost. And a lot of people come in, I'll tell you, we get clients who, people with good money, companies with real money, and they'll come in and they've got plenty of money, but they get sick of writing those checks, and they also get sick of responding to discovery. They get sick of sitting for depositions. They get sick of all those things. And you can get all the money back for the attorney's fees. You ain't getting all that time back. And so it seems a little, okay, well, we're going to be nice to them because their attorney screwed up. Well, you have that agency relationship, that principal agent relationship, and you got a problem. Go after the attorney and get a sort of malpractice claim against him. And I'm pretty sure that unless this is a big dollar case, that the malpractice and the malpractice carrier would look at this one and say, "Oh man, there's no question as to liability." The plaintiff's counsel did not meet the standard of care adhered to by practitioners in that jurisdiction, right? And that breached that duty and likely proximately caused. All you have to do is proximately cause the damages, losing the case. The malpractice carrier going to look at it and say, "Man, we're going to lose on that. We have to win the case within the case, and we're going to have to
write a check.
Let's write a check. We're spending $100,000 easy defending this, and let's write a check." And very likely the carrier and the firm might write the check if they're a big enough firm. They just might write the check themselves, but the malpractice carrier would probably tell them they needed to do that. Oh man, their premiums are going to be high for the next several years. Oh, I hate to think about that. But they're going to be paying some big premiums there for a while.
I am going to interrupt you real quick, Dan. I just want to welcome a couple new members. We were Gen X. Thank you so much for becoming a new member. Welcome to the family. Thank you. And Tara, thank you for becoming a new member. You guys are awesome. Thank you. All right. Sorry, Dan. I just wanted to make sure I grabbed them before I forgot.
Yeah, somebody, Alex. Notice the agent is notice the principal. That's right. When you have an agent and that agent is acting within the scope of their employment, then you are bound by the conduct of your agent. So it's
thanks, Tara. Thank you.
Okay, well, I've had my say, and more than I should have probably.
No, you're fine. You're fine. I always love having you and Rob up. You guys are the professionals here. I just, stayed at a Holiday Inn Express last night. So I play the part, but yeah, I'm not an attorney. So whatever.
I will agree that Rob is a much more handsome man than I am. My beard is longer though.
Shay.
I think Rob is in his chicken coop right now trying not to fall asleep. Rob's just like, why am I here? What is going on? Like, you guys invited me up here. Like, what is even happening right now?
You're not too far off. I've got a frozen water all in my. I've got 3 separate chicken coops, and all the water's frozen, and I'm having to deal with that.
Yeah.
But Dan challenged me to a duel, so I couldn't turn it down. I had to defend my sacred honor.
That's fair.
He's a lawyer, man. He's a lawyer, right? Okay, well, I say bye-bye now.
All right. Well, thank you guys for jumping up. That was fun. We're gonna finish this case, and we still have a couple more left after this one. So don't leave just yet. Before we do finish this one off, Alan, thank you so much for the 5 gifted memberships. That is awesome. Thank you so much. Welcome to the 5 new members. I appreciate that. You are awesome. Okay, we're gonna finish this one up. There's only a couple minutes left of this one.
All right.
Yeah.
Yeah, we would not want to keep the wrong entity in, so we'd have no objection to that.
Okay. I can put that in a proposed order too, then, if you want.
Please do.
All right. I think that was the only other thing on the table.
All righty. Thank you all.
Thank you.
Thank you. Thank you, Your Honor.
Oh wow, I was right. All right. So that one was fun. I don't really have anything else to say about that. We just saw it. Everyone just saw it. We got some expert opinion from Dan and Rob. So I do appreciate them jumping up. But we're going to move on. We're jumping to Judge Dad, also known as Judge McNally. We have we've seen this guy before. You're gonna recognize him. This is the guy that refused to clean up his house. He's back today. Let's go. Oh, real quick, MGT. I don't know if you're there. MGT let me know this was going on, so thank you, MGT. Let's go.
People against Robert Thomas Boyd, 25BA2557. How you doing, Mr. Boyd? Come up to the podium. Ms. Foley Carter, your name?
Caitlin Foley Carter, I'm from Township.
Mr. Boyd.
Robert Thomas Boyd.
So you're here for a review hearing, and you have the right to an attorney. If you would like an attorney, I'm going to give you one now.
No, thank you.
You waive your right to a lawyer?
Yes, sir.
Please tell me. Please tell me. Please tell me that there's been substantial progress on the property. I'm talking to the prosecutor.
Okay.
I would define it substantial, Your Honor. I did have a department, somebody took photos from the street on Thursday. It shows the boat, the off of the vehicle, the trailers. He got a large delivery of wood that is now in front of the property. There's junk along the side. I do have those photos if you want to take a look at it. I do see that the trailer in the back of the property is full. Mr. Boyd did say that it was full. It just needs to be cycled out and he needs to keep working on it. He also has not obtained a demolition permit yet for that dangerous building back in the back.
I don't know what to do with you.
I don't know how long it's good for, so I'm waiting and, I can't get the trailer out because the guy went up deer hunting and then he's up north with his boss working on.
Whose trailer is
what's
that?
happening.
Whose trailer is
So he's coming
that?
back,
Whose trailer is that?
The dumpster.
yeah.
Wait a minute. So it's being used as a dumpster, the trailer is?
The trailer is a dumpster.
Okay.
That dumpster, you can see in some of the photos.
Yes.
That is full. There's still all the trailers being used as storage essentially though on the property.
What are you doing with the boat?
Trying to sell it. Got a for sale sign on, it, got it out by the road.
How long you had that up for sale?
Well, it's the middle of winter.
No, I didn't ask you that. I just want to know, can I have
Oh.
another page, second page to a register of actions?
Since,
I think it's been about September or October, you know.
All right, talk to me, not to her.
No,
I'm
it's
just-
in November when we put it out there.
I mean, he does look a little better. I'll give you that. But you still gotta get the boat out and you gotta get the
Yeah,
garage torn down.
I've had the flu since Christmas.
What's in the trailer?
I believe that Mr. Boyd has taken property out of the garage and that's what's in the dumpster.
Well, no, but there's a trailer. Is this not a trailer? This black, it looks like a black trailer to me.
Yeah, there's about 2 or 3 trailers on the property. They're just full of, excuse my language, junk. So those need to go. You can't use storage like that on the property.
When are you gonna get rid of the junk in the trailer?
A lot of it isn't junk.
What's in the trailer?
Tools. I gotta put my, rototiller in there. My lawnmower in there.
Tools,
Yeah.
lawnmower?
Yeah.
What else?
Speed Racer. Thank you so much for the 2 months. I appreciate it. Thank you.
Is it filled up?
No,
What else do you have in the trailer?
I got some kitchen cabinets that I gotta put up
You're gonna put them where?
Huh?
Where are you gonna put them?
in the kitchen.
How long have you had the cabinets in the trailer?
November, December.
Where'd you get the cabinets?
My daughter. She,
What?
remodeled her kitchen. And, they're all handmade cabinets. They were too dark. She wants white.
Who's gonna take the dumpster out of there and take it to the dump?
The man who owns it. I rented it. $400 a shot.
Is it filled up yet?
Yeah, it's good.
When's he coming? When's he gonna come get that?
I'm gonna call him today, see if he's back in town.
What about the other inoperable vehicles?
The inoperable vehicle. Got a broken shock. I gotta put it into the.
Is that, these are the same vehicles been sitting out there?
They are, Your Honor. Same with the trailers. Those have all been there since we did this.
I don't know what you're gonna make me do, Mr. Boyd. I really, Mr. Boyd, come on.
I gotta work on the garage, getting it in. Everything else is secondary.
Well, that's your opinion. That's not my opinion.
We do one thing like that at a time.
Mr. Boyd,
Stop.
Mr. Boyd, I'm gonna let the prosecutor remind you how long they've been dealing with this, with your property.
Your Honor, I believe these citations date back to 2001.
So it's only been 25 years.
I didn't know about it.
Mr. Boyd. I don't know why you're not good. I don't know why you're just insisting that I send you to jail. I don't understand it.
I can't do anything, you know.
Mr. Boyd, you're not doing anything out of jail either.
Can't do anything.
Mr. Boyd, this has been 25 years. 25 years, sir. I was young. I'd like to go back 25 years. This is my early 40s, 25 years ago.
Nobody come and talk to me. Except for, the guy that retired,
What year did he come and talk to you?
just before Rob took over.
What year was that?
Last year, 25.
So you're saying you didn't know anything about this until 24? The township hasn't been bothering you to get this junkyard picked up, sir?
Well, he just come and.
Sir, I'm asking you when your first notice was from the township that you had a blight condition, they wanted things out of there.
Nobody called it a blight condition.
Sir, when did you hear from this township in reference to the condition of your property?
Probably 24.
So you guys are off by 23 years. She thinks it was 01, you think it was 24. That's one big difference. Now, I hear a lot of opposite stories here. Some people call it one, some people call it a million. I hear different stories, but that's quite a disparity. That's 23 years, not 23 days, not 23 weeks.
That's when I got the letter in the mail. 24.
Would you look on the computer, please, for me? Can you pull up Mr. Boyd's name, please? I like you. I do,
I like you.
but I have a job.
So do I. I gotta get that.
And you're not following orders of the court.
Nothing I could do with being sick.
Mr. Boyd, you've given me every excuse under the sun.
Oh, it's a bad flu.
Well, let me see here. I see Robert Thomas Boyd. Allow inoperable vehicles, 2002. Improper storage, 2003. There's other ones that were set aside under a statute, building code violation 24. So they were dating back to 02. I don't know why they let it go from 03 to 24, if that's what they did. But you've had since April of 25 to get rid of this stuff. And I don't know what to do with you other than just lock you up.
I think if it was,
Mr. Boyd,
2002.
Mr. Boyd, I've had every excuse under the sun from you. I don't know how many times you've been in front of me on this case. I have had every excuse under the sun. You're sick, you're Boys won't help. They're too busy. You don't have the money. You got to go to work. It's too warm. It's too cold. It's too this. It's too that. And here I am trying not to send you to jail and knowing when I don't send you to jail that I'm not handling my office appropriately. You know that? That's what I'm doing. I'm not handling, I'm just not following what I should do and what I do. So basically, somehow, some way, I've treated you better than I treat anybody else.
I appreciate it.
Well, no, but I don't want to treat you better. I feel sorry for you. I'm trying to help you. I'm trying to reason with you, and you're not taking any reason. You're just not going to listen to judges. You just don't. I don't know if you think I'm kidding up here.
I'm working on it. I've got 2 trailers full of junk out of there already. 2 dump trailers. They're big.
You got to get the garage done. You got to get the trailers out of there, the dumpsters. You got to get the junk out of the trailer. You got to make sure that your vehicles are operable, not inoperable.
Yeah.
Are they properly plated? No, they're not properly plated either, are they?
Yes, they are. And they're insured.
Why did the township wait so long? If they were dealing with this in 02 and 03, what took them 21 years to start?
It wasn't
Hang on,
like that.
hang on, let me talk to her. I was talking to her. I wasn't talking to you. Why did they wait so long?
Jerry, do you know that who's issued municipal civil infractions that are handled through the township along with multiple notices?
Are you gonna deny that too?
What?
She just told me that multiple municipal civil infractions, which would not have been filed here, were issued to you many times between 03 and 24. Is that true or is that false?
I had.
True or false? Just give me a straight answer, please. I don't want to have to be a dentist today. I just don't. Is that true or false?
Well, it's not that simple.
Did they send you certain municipal civil infractions or not? It is simple. What's hard about that? It's either yes or it's no.
In 2003, I had 2 cars in my yard.
Mr. Boyd, I'm just asking you a simple question. Between 2003 and 2024, did this township send you municipal civil infraction violations or did they not? In other words, is she lying to me? Is she lying to me?
I wouldn't think so.
Okay, so she did, so they did send you notices, right?
But I have.
Right?
People.
Right or not? Please tell me if I'm right. I'm gonna get agitated if you keep playing with me. Did they send them to you or not?
I don't know.
You don't know?
My ex-wife picked up the mail.
Oh my gosh. You know what I want to do to that? That's what I want to do to that. That's ridiculous.
She didn't like me too much.
Boyd, you got 2 months to get everything taken care of. I'm going to give you one last chance. This is not a threat. This is a promise. I'm going to adjourn the review hearing. You've got to get, you got to do this. This is not a request. This is not a suggestion. I'm not asking you anymore. I'm telling you, this is what you're going to do. Do we understand one another?
Yes, sir.
The last thing I want to do is put you in jail. But I'm going to do it if you don't have the property cleaned up like I've told you multiple times. Give me a date in the end of March, Heather.
We could do March 25th, Judge.
March 25th at 8:30 in the morning. You want to take your, did you have something to say?
Just briefly, I did want to remind Mr. Boyd, I know we talked about it a little bit, is that there's a Good Samaritan with a team of people that want to volunteer to help him clean his property. It's my understanding that he says that he doesn't need her yet, that he had one person before, but I think that this is a much larger problem.
They'll help you.
Yes, sir.
If you,
I have to have somewhere to put it. The trailer in my yard, the dump trailer is full. That guy's been away for 6 weeks.
well, tell them to come and get it.
I did.
Listen to me.
He's telling me.
Take the help that the township's offering you. There's gonna be no excuses next time. You understand? You do what you gotta do, but I'm telling you right now, you've been in front of me on a multitude of occasions.
Didn't this guy already spend some time in jail? I feel like we've been watching this guy now for, I don't know, the last year. I swear he went to jail for, I don't know how long it was, 5 days, like 3 months ago. I might be confusing the case, but I feel like that was this guy, right?
On this case, and I'm telling you, if you don't have that property cleaned up to my satisfaction in compliance with the orders that I issued previously, I'm giving you the other remaining days, whatever they are. Do you understand me?
Yes, sir.
Take your photographs back, please. You can keep these and you can mark down what day they were taken so you can bring them next time and have updated photos. Thank you very much. Go down the hall, get your notice, sir. Good luck. I'm telling you, I'm not going to do this again. Marcus Liddell Allen Jr., 25B149, 652.
All right. All right. We have one more case. This is a very short one. It's only about 3 or 4 minutes long, but I feel like it is the perfect end to the evening. It'll make you chuckle. It'll make you smile. We are moving to Judge Simpson's courtroom. I am going to peace out. I'm just going to let this run through. It's almost 9:30. So, I'm about to turn into a pumpkin. So I'm going to call it a night. Thank you guys so much for watching. I do appreciate it. It was a great evening. Thank you for Rob and for the epic Dandolph the White for joining tonight to discuss a little bit. I do appreciate that. That was a fun and unexpected turn of events. So I do appreciate it. Thank you guys for the super chats, the gifted memberships, the membership milestones. You guys are awesome. Speaking of membership milestones, Sharky, I did not forget about you. Thank you so much for your 15 months. I do appreciate it, Sharky. Speaking of Sharky, thank you for the mods who do excellent work on my behalf. I do appreciate each and every one of you. So thank you very much. All right, I'm going to go find someone to raid. It being Wednesday, we are probably going to raid Katie Zed this evening. Yeah, you know what? I'm just going to call it. We're going to raid Katie Zed. So make sure you go tell her I said hi, but you're not going to want to miss this last one. It's funny. You're going to see why. The second that it pops up on the screen, you guys are going to see why. All right, you guys are awesome. I will see you all tomorrow. Tomorrow night. For those of you that didn't see yesterday, my Tuesdays and Thursday streams for, I don't know, the next couple weeks while I test it a little bit, they're going to be a little earlier. So I'm testing between 6:30 and 7 as a start time on Tuesdays and Thursdays. Heather has an evening yoga class on Tuesdays and Thursdays. So if I want to spend any time with her, I'm going to have to move my stream a little earlier, and that's not hard to do. So I'm going to do it. So for the next few weeks, at least just to test it out, I'm going to be a little early on Tuesdays and Thursdays. Tomorrow night is Thursday. So I don't know if I'm going to be 6:30 or 7, some or somewhere in between. I don't know, but it's going to be a little bit earlier tomorrow night. So hopefully I'll see you guys then. But go tell Katie that I said hi. Thank you guys so much for hanging out. And yeah, that's it. That's all I got. Until I stand by.
Maybe seated. It's crazy. Court does call the case of the People versus Ryan Adkins.
Assistant Public Defender Natalie Page, Mr. Adkins. Looks like he's on Zoom. Sir, can you please unmute and state your name for the court? We are prompting you.
Oh, that's not him. Ryan Adkins,
Can you hear me?
yes. I need that camera.
I'm trying.
it might be him, but there's just a filter on his face.
You got to filter. You got to filter.
Yeah,
That's
I'm
it.
trying to turn it off. I don't understand any of this. The camera says it's there it goes. There we go.
Bill with the comment of the evening. What does the fox play? Bow, 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 bow. Yes, Bill. That was awesome. Thank you.
Normal.
Can you see me now?
All right. Yes, we can see you now. You're not
Sorry.
You're not some animal. All right.
Ryan
Where are we
Atkins.
at? Thank you.
Your Honor, this is a show cause, I believe, on the balance on the closed case. I believe the balance may be still $470.
Yes.
I did leave Mr. Atkins a voicemail, but we were unable to actually have a conversation to discuss this, so I would ask him to give,
Ryan, how you going to get this paid off?
Can you give me 30 days? I should be able to have it paid off in 30 days.
You know I can give you 30 days because I've done it before, but
right. Well, I mean, yeah. I should be able to have it paid off in 30. What is it
paid off by? Can you get it paid off by the end of February?
Oh yeah, for sure.
All right, I'm going to put in here defendant to pay balance by February 27th, 2026. I'll set a review to make sure payment, what's my date in March?
March 11th.
Set a review for March 11th, 2026, 9 a.m. If you got it all paid off, Ryan, I don't need to see you on that date.
Well, Jabba Puppy, judging by the fact that he's in space and a bunch of astronauts just got brought back to Earth, he might be unemployed for a little bit because he's not going to be on the space station anymore. So hopefully he can pay it. I'm hopeful. Or maybe he's still up there. That's why he's appearing from space. Yeah, I got nothing. I tried to be funny. This is what you get. This is 9:30 Colin. All right, you guys are awesome. Go tell Katie Z I said hi. I told you that was a fun one to end with. Till next time, bye.
Okay.
All right. Thank you.
I appreciate it. Thank you.
Yeah. Court calls case People versus